So Republican governors are going to be suing the Biden administration to stop the employer vaccine mandate. Is the administration on strong legal footing here, and will they survive this challenge? Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. If you share my concerns, maybe you could like this video and subscribe to this channel, and even click that little bell that will notify you when I post something new. So Republican governors are going to challenge President Biden's vaccine mandate in court. When asked about that, President Biden's response, and I love it, was, "Have at it." The president has good reason to feel confident. His plan is based upon a clear provision in the OSHA Act, the Occupational Safety and Health Act, which was passed in 1970. Section 6C of the Act says, "The Secretary shall provide, without regard to the requirements of Chapter 5, Title 5, United States Code, for an emergency temporary standard to take immediate effect upon publication in the Federal Register if he determines, A, that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards, and that such emergency standard is necessary to protect employees from such danger." So what are they talking about here? Typically, when an agency like OSHA is going to issue a standard that impacts employers or other parties that they regulate, they have to go through a whole process that's called rulemaking. The rulemaking process can take years. And the reason is that the agency needs to do what's called promulgating the rule, which means that they need to publish information about the rule they're proposing in the Federal Register, which is basically a booklet that's published every day detailing everything that the federal government's doing. And then there's a comment period where people who are affected by this proposed regulation get an opportunity to respond. Then the agency has to address those responses to show that the new standard is not arbitrary and capricious. In other words, that it's based upon two things. Number one would be federal law, that there's clear authority granted by Congress to the agency to promulgate the rule. The second thing would be that it did the proper research to make sure that this rule is properly implemented. After all, when Congress passes legislation, it leaves a lot of gaps in what needs to be done. Those gaps get filled up by the regulatory agencies and their rules. Typically, this process can take years, and it's subject to a lot of lobbying. In fact, more money gets spent on lobbying the rulemaking process than actually gets spent on making legislation in Congress. So what's different about this provision, it specifically says that when employee safety is at risk, the secretary, who of course works for the president, can essentially immediately promulgate a rule that takes immediate effect while the agency goes through their typical rulemaking process. The authority to do this couldn't be any clearer in the statute. So President Biden is on sound legal footing here. Of course, you never know what courts are going to do, but if the courts properly follow the law, it's pretty clear that they will give the administration the flexibility here. The only requirements are two things. Number one, the agency, when they first announced the rule, would have to make it clear that A, employees are exposed to grave danger, and B, that such emergency standard is necessary to protect employees from such danger. So they would have to put information about that in the rule itself that they are issuing. The second thing they have to do is they actually have to start the rulemaking process anyway of a new rule that will follow the normal procedure. So as long as OSHA does both those things, the administration's on pretty strong legal footing here, and I don't think they need to worry at all about any issues coming up in courts. I think the Republican governors probably know this, and their position that they're going to sue is probably more political posturing than anything else. After all, Texas Governor Abbott basically was elected governor on the strength of the fact that he repeatedly sued the Obama administration while he was Attorney General in Texas. So the Republican governors view this as good politics. What's more is the governors like DeSantis and Abbott, both of whom are up for re-election this year, are worried about the fact that COVID is tearing through their states. Yes, they may not show it, but they know that the huge death rates that they're experiencing is starting to affect their standing. But yet they can't back off from this, because if they do that, then they anger the Republican primary voters who they're trying to curry favor for the 2024 presidential election. So I think Republican governors really breathed a deep sigh of relief with this. Number one, they get to appear that they are fighting the Biden administration, something that's red meat for their MAGA supporters. And the other thing is, this mandate will probably start to address the problem of the virus and its variants in their states. That's the irony of this whole situation, is that what Biden did more than anything is going to help Republicans. He, unlike the former president, is trying to be president for the entire country. And he's going to do it despite the fact that they're going to fight him every step of the way. And that, my friends, is what they call leadership. And we should applaud President Biden for it and support him 100% in his efforts. Well, if you agree with me or disagree with me, I'd love to hear your comments down below. And if you could like this video and maybe subscribe to this channel, that'd be a huge help. I'll see you in the next video. In the meantime, let's hope for continued progress. Thank you.